take us away.
So welcome everyone on behalf of the Tel Aviv University Faculty of Law. I would like to welcome you to the webinar on the EU Data Strategy and the Draft Data Governance Act. We have an impressive list of distinguished speakers, so I will be very brief. All of us here today know that data is increasingly important in the modern economy, and this leads to two goals that are somewhat in tension. To the extent that information is personally identifiable, it stresses the need for mechanisms to protect privacy, but at the same time, access to data is essential to facilitate academic research, to promote competition, and more generally to foster economic development. And these objectives that are somewhat in tension require governments to devise strategies to meet the challenges of that digital transformation. And they also call on policymakers, scholars like myself and others, and lawyers and other thinkers to develop institutions that would facilitate different forms of data ownership and sharing. The Draft Data Governance Act aims to foster the availability of data for use by increasing trust in data intermediaries and by strengthening data sharing mechanisms. I have no doubt that these initiatives will challenge other jurisdictions, maybe including Israel, to develop their own data strategies. I thank our speakers for taking the time to share their insights on this topic. And most importantly, I thank Limor and the Israel Tech Policy Institute and Stacy for co-sponsoring this event. And I look forward to our discussion. Limor, please.
Thank you. Thanks, Asaf. And I really appreciate and enjoy our excellent and productive partnership on this event on our other collaborative experiences. And I share your thoughts and will really make it brief, just to maybe mention how data governance is pivotal in the work of both ITPI and myself from my past. As being in charge of data protection, enforcement, and regulation for the Israeli Privacy Protection Authority for quite a few years. So I fully appreciate the risks associated with using data and collecting and processing data in light of privacy and security principles. But I also very much believe in data solidarity and in the necessity to use data for good purposes. Several years ago, I was asked by my HMO, my health management organization here in Israel, to consent to my biosamples to be collected and made part of a research data lake that they established. I knew fully well the meaning of this donation, maybe more than most. And I immediately decided that my answer would be yes. And I knew what this means both for myself and for my extended family. I didn't receive any compensation or benefits or added services from the HMO. And to this day, 5 years later, I haven't regretted this decision. I'm very much interested in these debates and very much interested in these concepts of data altruism, data co-ops, data trusts. And I'm fascinated with the EU data strategy. And I'm looking forward to hearing all of our great speakers here try and help us understand how it's going to look like. So without further delay, I'd like to invite our first speaker. Regretfully, Mr. Malte Katzenberger was not able to join us today due to Parliament and Commission discussions, but we are very fortunate to have with us his colleague, Maria Rosaria. Ms. Rosaria Codotti is a policy officer at the European Commission at the DG Connect. She took part in the creation of the DGA, and I invite you to share with us the EU vision for the Data Governance Act. Maria.
Thank you very much, Limor. Thank you very much for your kind words. So while we're waiting for the presentation, yes, it's coming. I will briefly introduce the data strategy and speak more in depth of the Data Governance Act. So next slide, please. I think that we can all agree that data digital technologies are becoming more and more important in our daily lives for boosting our production, for having better healthcare, for having better management of traffic jams in cities, for having better urban planning in cities. So the data strategy comes from the realization that the potential of the use of data for the benefit of the society and the economy is huge. But we observed that this potential, at least in Europe, is still not harnessed. The data strategy is the answer to a number of questions and problems that we have observed in Europe. For example, that not enough data is available for reuse, not enough public sector data is available, there are no mechanisms for voluntary data sharing, data altruism, no clarity on the use of private sector data for the common good. Then we also observed a lack of European data processing, a storage solution, because even if we have the data, but then we don't have the secure, trusted infrastructure to share the data and to process the data, we cannot do much with all the data. There is a lack of governance in Europe to address all the legal and technical obstacles to data sharing, not only between member states, but also across the different sectors of the economy. There is a lack of personnel equipped with the right skills, the digital skills to work with the data. So data literacy is very important. There is a fragmentation of the single market because we observed that some member states are progressing more than others. So we run the risk of having 27 legislation saying different things about how to deal with data. So we don't want that, because that will impede on the well-functioning of the internal market. And then there is not enough real user empowerment. We know that the Article 20 of the GDPR on the data portability is not that easy to be implemented. So we want to help also on that side, and really having the individual and the companies in control of their data. Next slide, please. So that's why we published the data strategy that is built on 4 pillars. The first one is an horizontal framework, a cross-sectoral governance framework for data access and use, where we lay down the principles for the Data Governance Act and also for the other legislative action we are working on, that I will talk about them briefly later. The second pillar is about enablers, investment in data and strengthening Europe's capabilities and infrastructures for hosting, processing and using data, and also strengthening interoperability that is crucial. The fourth pillar is the one of competencies. So we want to empower individuals and invest in digital skills and digital literacy. And then we also want to roll out several common European data spaces in crucial sector or domain. And we will talk about that later too. Next slide, please. So the Data Governance Act is the first legislative proposal linked to the implementation of the data strategy. The essence of the Data Governance Act is about creating the right conditions so that if people want to share their data, they can do so in a trustful way. So it's not at all about having to share data. The Data Governance Act wants to create an alternative model of handling data than the model we are now used to see, and specifically the model of the big tech companies. The Data Governance Act tries to offer a response to some issues like the high transaction cost for data sharing, the insufficient availability of data for reuse, and emerging regulatory fragmentation, as I was mentioning at the very beginning. So the ultimate objective is to create a single market for data, a genuine single market for data, where data can flow across borders and across sectors in a trust and secure way to benefit the economy and the society. Next slide, please. So the Data Governance Act also built on 4 pillars. The reuse of sensitive data held by public bodies. It provides a framework for new data intermediaries in the single market. It provides provisions for the data altruism, so to allowing people and companies to share data for the public good. And the last pillar is the coordination and interoperability one, when we will talk about the European Data Innovation Board. Next slide, please. So first, for data held by public bodies, we want to enable the possibility to tap into those data that are currently not shared because they are sensitive. And they are sensitive because they concern someone's right. Those rights could, for instance, be on intellectual property rights, commercial confidentiality, or privacy. And with these new rules, such data can now be shared. They can be made available for use because their level of legitimate protection will be maintained, even if they travel to another countries. Next slide, please. Second, to facilitate data sharing, we are creating principles for trustworthy intermediaries that will provide the basic infrastructure for data sharing. The principle behind intermediaries is to boost voluntary data sharing whilst preserving control over the data from companies and individuals. This will only work if those intermediaries are fully trusted by both the data holder and the data user. Several caveats will ensure this trust. To start with, intermediaries are required to notify the competent public authority of their intention to provide data sharing services. They will ensure the protection of sensitive and confidential data, and they will have to comply with strict requirements to ensure their neutrality. In practice, this means that data intermediaries will function as a neutral third party that connect data holder and data users. This is all about providing a safe environment for those willing to share the data. Next slide, please. The third element of the Data Governance Act is that individuals or companies allow their data to be processed free of charge to serve the general interest purposes, such as the scientific research purposes, fighting epidemics, or making local transport more efficient, understanding better traffic flows. Under this regulation, organizations that respect certain transparency requirements and ensure that the rights and interests of data subjects are safeguarded can choose to be recognized as trusted data altruism organizations. A European register of such organizations shall be created. By creating a trusted framework, these measures will encourage Europeans to make their data available while fully respecting their anonymity for the benefit of the society. In addition, a common European data altruism consent form will be developed to allow the collection of citizens' data across member states in a uniform format, facilitating the use of data union-wide. Next slide, please. A European Data Innovation Board will be set up. This will be a formal expert group with a secretariat provided by the European Commission. It will include among its members the representatives of sectoral data spaces, aiming for a balanced representation of all the different sectors across Europe. It will be responsible for facilitating the exchange of national practices and policies of data altruism, data intermediaries, and use of public data that cannot be made available as open data. It will also advise on the prioritization of interoperability standards for cross-sector and cross-border data reuse, and on the establishment and maintenance of a schema of standards, both legal and technical, related to problems common to all data sharing situations, irrespective of the sector. Next slide, please. The Data Act is about the next steps. We are currently working on this other legislative instrument that is going to be the last major legislative instrument under the data strategy. We are indeed working on a super study and an impact assessment for the Data Act, which will aim at ensure that all the value generated by the use of data is shared in a fair way across all the data value chain. And we will look at how to increase data sharing in business to business settings, business to consumer settings, and also in business to government data sharing. So we will also look at ways of increasing the use of privately held data by public authorities for common good purposes, such as epidemics or for public safety, or for statistics, or for any other purposes that can be useful to public authorities to do something good for their citizens. A public online consultation will be published soon, so stay tuned. Next slide. This is the end of my presentation. I just also want to mention that we are also working on in implementing act on high value data sets from the Open Data Directive. So to make even more data produced by the public sector available for reuse, free of charge through API, so that everyone can benefit from this data. So this was a short introduction. I hope I respected my time limitation, and don't hesitate to, if you have any further question, to contact me to the email that I just showed in the presentation.
Thank you very much. You excelled in meeting the time requirements. Actually, we have some, so that leaves us with time for one question. I'm actually going to ask a question that was asked by our next speaker on the chat, by Henrietta, and her question is, if the Digital Governance Act aims to facilitate data sharing, why does the act propose to impose such restrictions on intermediaries, on data intermediaries, like, for example, the requirement to put it in a separate entity that would just engage in those type of activities?
We don't want to put onerous requirements on data intermediaries, but for them to work, they have to be completely neutral third parties. We cannot have data intermediaries that then use the data that they have had access to for their specific purposes that maybe were not intended as purposes by the data holder, for example. So we just try to provide the safest and neutral, the most neutral environment as possible to really stimulate data sharing and data use. So if the data holder knows that the data that is going to share with the data user will not be used for other purposes, it will not only will not be used for other purposes, but it will also be used following specific rules and requirements. Then we create more trust in data sharing. So these measures are not aimed at, let's say, punishing the data intermediaries, not at all. We want to increase the use of data intermediaries in Europe. That's why we pay a lot of attention to provide safeguards that, you know, the data sharing happens in the best way and secure way possible. Yeah, we want the data intermediaries to become a tool for companies and individuals to help to actively engage in data sharing, and their business model will be supported by transaction fees. We are not saying that, you know, data intermediaries have to provide for any cost related to the data sharing that they facilitate. And of course, to ensure the neutrality of the data intermediaries, there has to be absence of any conflict of interest, and there has to be total openness of their actions.
Mm-hmm. And I think we have maybe just one more minute for a second question to Maria, if that's okay. There's a question from the chat. How will this apply to commercial companies? So
it depends. I mean, if a company has the requirement set out in the DGA to be seen as data intermediaries, then it can go for it.
Okay.
Evaluations will also be done case by case and according to the provision of the DGA.
Okay, so a data intermediary can be both a nonprofit or an academic entity or a commercial company?
I would say so, even if now I don't have in my mind an example of a data intermediaries that is an academic institution.
Mm-hmm. Okay, thank you so much, Maria. And this was truly fascinating, and it promises to be a start for our discussion during this webinar. And now to complete our setting the stage part, I'd like to invite Ms. Henrietta Tillman, Senior Counsel at Covington and Burling, based out of Brussels, to help us understand the puzzle of laws and regulations involving data that the DGA is going to be part of in light of recent policy initiatives. So thank you, Henrietta.
Thank you, Limor, and thank you for your kind invitation to have me participate in this very interesting program. So I've been asked to provide a very high-level overview of some data EU-related data initiatives, other than the Data Governance Act, which was just discussed by Maria. The slide you have in front of me, I hope you can read it. It's extremely dense, but I'll walk you through it. On top of the slide, you see 4 boxes in different colors. And the two first boxes, they concern existing legislation and legislation in the making on personal data, as the term is defined in the EU, and you know that it's defined very broadly. The first one relates to the GDPR. I think we're all familiar with it. It requires no further explanation. The second one is the e-privacy directive, hopefully soon to be the e-privacy regulation, which deals with processing of personal data in an electronic context. And for most people, the e-privacy directive / regulation is most well known for its provisions on cookies and its provisions on unsolicited commercial communications, i.e. spam. The focus of my 15-minute presentation, or what's left of the 15 minutes, will be on the third column, which is a series of initiatives taken by the Commission and presented by the Commission as part of its 2020 Commission strategy on data. And the Data Governance Act, which we just heard discussed by Maria, is a very important part of this Commission strategy, but it's by far not the only part. And I'll walk you through the various columns, time permitting, and we'll start obviously with the first one, which is a very recent, as a matter of fact, last month released proposal for artificial intelligence. A very important piece of legislation, I think one of the first ones, if not the first, to be introduced, whereby the Commission hopes to harmonize the rules that would be applicable in the EU member states on artificial intelligence systems. And it will not come as a surprise that the Commission is trying to set standards here that would be, that's at least the aim, that would be applicable beyond the European Union in a more worldwide setting, pretty much like what they did with the GDPR, and admittedly with some success. There's lots of privacy legislation that's based on the GDPR. When we look at the proposal, which, as I said, came out only last month, there's a couple of things we can say. It's a risk-based approach, and I would add quite a cautious approach, and that probably explains why one of the first provisions that you see in the proposal, in the draft regulation, is a series of artificial intelligence practices that are banned in the European Union. There's 4 of them, and the one that that jumps out and that's going to cause the most discussion in the Parliament and in the Council, where this proposal is now being discussed as we speak, is the one on a real-time remote biometric identification, i.e. facial recognition, by law enforcement agencies in public spaces. It's interesting to note that in some of the earlier drafts of the proposal that were leaked, drafts are always leaked, the facial recognition by law enforcement was actually not banned. It was allowed, subject to very strict rules. In the proposal that finally came out, it moved up to the banned IE practices, but with wide exemptions. So there are a series of circumstances where law enforcement would be able to use facial recognition. And these exemptions are then in turn subject to strict conditions. So it's not entirely clear at this stage whether the original proposal, it's allowed subject to conditions, whereas now it's not allowed, but subject to wide exemptions, which in turn are subject to conditions, whether there's all that much difference. But it's an optical difference, that's for sure. What is also sure is that facial recognition by law enforcement is going to be a very hot potato in Europe, because especially in the discussions in the Council, because not all of the member states are on the same wavelength. And obviously the member states need to agree on what the final rules will be. Aside from the AI practices that are banned, the rest of the proposal focuses on high-risk artificial intelligence systems. Somewhat to everybody's surprise, certainly my surprise, high-risk IE systems the term is not defined in the regulation, and the reason for that is that the Commission wants to make sure that the proposal is future-proof, which in its opinion it wouldn't be if there was a definition. But there are in 2 annexes, Annex 2 and Annex 3, a series of criteria that would allow a provider or a user to know whether a system that it is using or putting on the market is considered to be or should be considered to be high risk. One of the annexes, Annex 3, refers to a number of areas, and it indicates that if you have a product or a component of a product that's going to be used in those areas, that would be considered high risk. And one of the examples, but there are others, is for instance the area of educational and vocational training. So if you use a product that has an IA component to, for instance, figure out who's going to be admitted to your school, or who can enroll in a training program, that would be high risk. One example, there are others, Annex 3. Annex 2 is the more complex one because it has a very long list of existing product safety directives on a variety of issues like machinery, medical devices, toys, etc. And what the regulation says is that if you have a product or a component of a product that's currently regulated by any of these product safety rules listed in this Annex 2, that's subject to a third-party conformity assessment under the current rules, then that additional IE component or additional IE product would be considered high risk. I think there will be quite a bit of confusion as this thing moves forward as to what exactly that means in practice, but that remains to be seen. Once you know that you have a high risk IE products, you're subject to a stringent set of regulations, which leads me to believe that it's the whole approach of the Commission is risk-based, but also quite cautious. The Commission takes a cradle-to-grave approach. There's lots of requirements before the product is put on the market, but there's also post-marketing monitoring, reporting of incidents, malfunctioning reporting. So it's basically cradle-to-grave. Centerpiece is a conformity assessment, which can be either self-assessment or by an independent third party. But there's a variety of other rules on the risk management systems that need to be put in place, on the quality of the data that you will use to feed the algorithms, which makes sense, on training models, on technical documentation, on record keeping, etc. The enforcement of the regulation is, as is customary in these types of regulations, is left to the member states. And there will be created a European Artificial Intelligence Board. There's lots of boards that are going to be created in Europe. This is one of them, a European AI board that will sort of coordinate, streamline a little bit, and create some best practices. So that's AI, very important piece of legislation. Data governance we can skip since it was very well handled by Maria, nothing more that I can say there. Then we come to another very important piece of legislation of a totally different nature is the DSA, the Digital Service Act. It's geared towards providers of online intermediary services of various types, services that offer network infrastructure, hosting services, platforms that bring together sellers and consumers. And it basically, this is very high level, and in a nutshell, it tries to do two things. First of all, it provides rules on the liability of these providers and for third-party content, and the accompanying content moderation rules that these providers need to comply with. That's the first part. The second part, the second aim, is to impose obligations and restrictions of all sorts of nature on these various providers. Few words on the content moderation and the liability. A couple of large principles is that in principle, these providers are not liable for the information that's transmitted or stored, not liable, but they do need to act promptly when requested to take down certain illegal content or to provide information. And second important principle is that there's no general obligation for them to monitor the information that they transit or they store. So they need to react when asked, but they don't need to actively monitor. So for them, that's obviously very important. On the obligation, which is the second aim of the draft Digital Service Act, there's a whole series of obligations that the intermediaries would need to follow. Too much to go into detail here. But what is important and what's interesting to note is that the Commission goes out of its way to distinguish between various types of providers and aims to impose obligations and restrictions that match the size, the role, and the impact of each type of these providers in the online ecosystem. So you would have sort of basic provisions that would apply to even the most innocent, conduit and cash providers. Then you have additional obligations on hosting services and online platforms, and even more obligations, the most stringent was actually, on the so-called large online platforms, and that's a term that's defined. It's platforms that provide services for at least 45 million active recipients in the EU per month on average. So a cascade of obligations and very much trying to be proportionate and sort of saying, this is your footprint in the ecosystem, so these are the obligations you need to comply with. Again, we've also seen what we've seen with other proposals in this area is enforcement is left to the member states. They will all have digital services coordinators, and there will be a board, European Board for Digital Services, sort of coordinating and streamlining and that kind of thing. We then move on to our, in rapid pace, we move on to our onto our screen to the Digital Markets Act. Digital Markets Act is a bit of an outlier, I find, in this whole overview, because it's basically competition law tools. It offers competition law tools and tools with real teeth, I must say, to the authorities, mainly the EU authorities, to deal with online market behavior. The law applies to core platform services that are provided by so-called gatekeepers. And core platform service is a defined term. It's a very broad term, and it includes things like search engines, social networks, video sharing, cloud computing, advertising services. And when these services are offered and the provider of these services meets certain conditions, then that provider would be considered a gateway and then subject to these provisions. This one is one to, as I said, it's a bit of an outlier because it's basically for competition lawyers, but it's one to keep an eye on because the thing really has teeth. And then we move, I use the last few minutes to the fourth section, the purple one on the screen, which is the important provisions on security and cyber, with especially the Network and Information Security Directive number 2, which 2 indicates obviously that there was a 1. So it's an update, and it has a broader scope, stricter oversight, harsher penalties, and it's basically being updated to, you know, the new realities of the world. That, in a nutshell, very nutshell, is the Commission strategy, the 2020 strategy, and all of these things are now moving to the Parliament in various committees. And as we say over here in Brussels, sometimes the cat doesn't find its own kittens in this thing, but it's all moving forward, and at some point of time, it will all lead to new legislation. Thank you.
Thank you, Yeri. That was most enlightening, and I was wondering, and feel free to tell me that it's too soon, but I'm trying to imagine, for example, whether data sharing entities or data intermediaries under the DGA, will they be also accountable for the DMA and or the DSA and or other regulations? GDPR, of course.
It's certainly not excluded, but each of these provisions, even though they're all part of the same program, each of these proposals, they have their own definitions and they have their own set of conditions. And if if an entity, whatever it may be, a data intermediary that qualifies as a data intermediary under the DGA would qualify under the DMA or under the DSA, then there's no reason why it would be excluded. Now, we've heard from the previous speaker that the data intermediary, it can be a commercial entity, and then there's certainly no reason why it would be excluded. The fact that it's a separate, that it has to be a separate entity of the commercial entity probably makes it somewhat less likely that it would fall under the definition that it, for instance, would meet the threshold of the DMA, but in principle, it's not excluded. But I don't think it was the general idea that data intermediaries, which are meant to be neutral, which are meant to be non-monetizing institutions, would be covered by it, but it's certainly not excluded. So.
We have one, since we have 2 minutes and one question in the, now 2 questions in the Q&A, I will ask the first question. Will the issue of data ownership be addressed by any of these proposed new laws or regulations?
It all depends what you understand under data ownership. As a red line through all of these proposals, because you have the actual proposal and you have about 25,000 pages of explanatory memorandum, and often there's lots of very interesting information in that in those explanatory memoranda. But as a red line through all of this, these documents, is the fact that existing rights, and data ownership rights would be existing rights, are not to be touched by all of these regulations. So I think in principle the answer will be no.
Maria, do you also want to weigh in here?
If I may,
yes.
Yeah, if I may, on this point, we don't really like to talk about data ownership because we think that it implies some exclusivity rights that will not help in using the data for the benefit of the society and of the economy. But do we talk about rights on the use of data, so usage rights? I would say definitely yes. That it is also one of the main objective of the Data Act will be to clarify usage rights over the data. I don't see ourselves, proposing a legislation on data ownership tomorrow. It's not at all in our mind, because we think that other things are a bit more important. And then we think that if you want to boost the sharing and the use of the data, that's not the right way to go. But it's better to clarify who can do what with the data, which are the rights of the data holder, the rights and the obligation of the data user. So it's by clarifying these issues that then we really enable a better use of data. At least, I work at the European Commission, so in Europe.
And Maria, we also have a question that I don't know if you can answer, but is there a tentative timeline for the Data Governance Act to be passed?
It is now in the negotiation phase. We are working with the Council and with the Parliament, and the work is going well. There is good cooperation between the co-legislators, but I cannot tell you when the legislative process will end.
Mm-hmm. Okay, thank you.
Not in the next 2-3 months for sure.
Yes. Okay. Asaf, any last question, or are we moving onward?
There is a somewhat technical question in the QA. Maybe one of you could, from Fred Ryan in the US about the official language of the EU. Maybe one of you could type an answer in the chat. But otherwise, Limor, I think it's about time to introduce our discussants. So
yes. Yes.
Yeah,
so,
I mean, as you wish. I can quickly say that our working languages are mainly English, French, and German. But all the documents and all the initiative, all the public online consultation are translated in all the 24 EU languages.
Thank you. So thank you very much, Maria, and thank you very much, Henriette. And we are now moving to our first discussant, Dr. Thomas Harjono. Welcome and thank you for joining us. Thomas is the CTO of Connection Science and Engineering at MIT and the Technical Director of the MIT Trust Data Consortium. And among his many activities and achievements, Thomas is the co-author of 2 books about how to empower people and communities with user-centric data ownership. Speaking of data ownership, and you will probably soon enough tell us what you think about this term, and also transparent and accountable algorithms and secure digital transaction systems. Thomas also wrote about how to create an internet of trusted data in which insights from data can be extracted without collecting, holding, or revealing the underlying data. So Thomas, I look forward very much to your insights about the proposed DGA model and your thoughts about data sharing in general.
Sure. Thank you, Limor. I only have one slide. Should I just share it?
Sure.
Okay. Actually, how do I? Okay, so somebody needs to enable me.
So Stacy will give you the permission to share, and.
Well, you know what? Maybe it's not. Why don't I read from it?
Sure.
Because it's this set of it's a set of challenges, and so in general, I think this is a good direction for the European nations to work on this framework. I think this at MIT, we've been wondering about this question for a long time. Our interest in this area goes over a decade. I think probably the first important publication that we were instrumental in authoring was the 2011 World Economic Forum report on personal data as a new asset class. And in a sense, when I'm reading this draft DGA, it feels like, well, maybe there's a recognition that public data is also an asset. It's a public asset. It's not free like air. Let's just say when air is becoming non-free, but there's a recognition there, and therefore that public data needs to be treated as well as good, as comprehensive as we treat personal data. So I think reading, I think I would have to. I want to wait until the other report on the services, I think, is coming out, is drafted. I haven't seen that one. I've only seen the DGA document itself. So that's sort of the first bullet. I think following Hendrik's comment, I think there's going to be some interesting questions about the providers of the data sharing services, right? Because on one hand, you have the data holders, and you have the users or reusers of data consumers, whether it's other public institutions, private corporations, or even individuals and communities. Certainly, communities would be interested, because local communities would like to know just general insights and even general statistics about their community. Everything from transportation to spending patterns to spending on the amount of expenditures on schools and so on. There's a lot of basic sort of information that the digital community needs increasingly, and so I think this is a good move. And the question then becomes, well, what are the obligations that will be placed on these data sharing providers? Because Limor mentioned this idea of what we call open algorithms, OPAL, that came out of our group at MIT, and basically it's based on the realization that in many cases, the use cases, the data users or consumers are interested in insights. They're not really interested in holding raw data, particularly if raw data is petabytes and petabytes and petabytes. And I think Maria on her slide had a bullet that, where do we store all this data? Because it's just going to get worse, and with the coming of IoT sensors, people are putting IoT device sensors in cars, on the roads, on lights, and so on. It's going to generate so much data that it's going to be impractical and even unattractive economically to move it around, right? And so what we've looked at is the idea, well, if indeed the data consumers are interested in insights, then maybe we could help them by constructing certain algorithms or questions that are targeted for specific data sets, public data sets. So instead of moving the data around, why don't you just put the data where it is? If it's a government organization that has transportation data about the nation or communities, then let them manage it. And perhaps as part of the framework is to define a standard set of APIs, application programming interface, where people can ask questions, right? So that if a local town wants to know a question, it knows who to ask the question to, it because it knows that that entity is holding the data. Now, with this data sharing providers, the providers are now basically acting in surrogate of the government, the public sector or departments within the public sector. And so there's this interesting question as, for example, when we follow that model where the data user, data consumer is asking a provider to compute something. Here's an algorithm to compute, average distance traveled by, people in Boston. I mean, who own a car, who ride a bicycle, who take public transport. Those insights are valuable in itself, right? And so, who owns those insights? So there's this question, Maria. Yes, we don't want to talk about data ownership. We want rights of use, but then also, what is the right of use for the insights coming out of this computation? Is it just is it going to be intellectual property of the provider, right? And if it's not, then what's the business incentive for the providers to even step up and say, okay, well, because they have to get something. I mean, it's a business. I mean, the private sector, needs to make revenue to maintain the infrastructure, hire and educate technical folks to run the infrastructure and so on. And so maybe some kind of a combination where the insights, certain types of insights that are statistical in nature, aggregate in nature, could be shared publicly. For example, questions such as average distance traveled by people in Boston. Everybody in Boston would like to know that. I mean, the Uber drivers like to know that. But if it becomes very, very narrow, then and very complex operations, then maybe there's a way for the revenue to be shared, so the data user, the data consumer who is asking for this algorithm to be computed, they have to pay the data providers, right? And so this brings in the whole question of what is a fair remuneration model for data providers that have to do all this heavy work in maybe even not just running the algorithms, but maybe even storing some of the data securely. And is there a way for the both the government side, the public sector side, and the data user side to jointly remunerate the data providers, right? So the business model to me is very intricate and fairly complex. And if it becomes too burdensome, no one is going to step up to the plate. So that was another point. And the other thing that we are studying a lot. So our group at MIT is a computational social science group. So we're interested in using data and data-related technologies to understand a society better, and to help as Maria was saying earlier, solve some of these problems. I think it was slide number 1. Detecting and preventing spread of diseases, addressing inequality in the economic structures of communities and so on. But data itself can have inbuilt bias. So this is a huge research area. There's dedicated conferences just on bias and unfairness in the data set. It's nobody's fault. It's just the way the data set was produced. Had it. But then there's this other more interesting question. Does the algorithm, does it actually have implicit bias in it, right? And so the other question then becomes, well, how would you vet, who is to vet that the algorithm and the results, the insights computed, are going to be fair across a given data set, right? So these are some of the challenges I believe that the data provider, the data sharing providers will have to face. And I think before we even get into the details about algorithms and data ownership, I think trying to understand what the business model, incentive model for these new service providers, I think needs to be addressed upfront. So that's kind of the end of my list. I said it's only one slide. I wanted more of a discussion versus just me talking. So please feel free.
I just mentioned that we have a couple of interesting questions in the chat by Darren, but we'll wait until the end of the of this panel, and then maybe we'll ask and people will take questions. So Limor, please, you want to introduce the next speaker?
Yes, thank you, Thomas. I also have a few questions written down, but we will finish our first round. And now let us turn to Ms. Helena Koenig. Helena is the Assistant General Counsel at MasterCard, responsible for global privacy compliance assurance, and is also MasterCard's Europe Data Protection Officer. And Helena, I know you're very much interested in this EU initiative and EU strategy, and hopefully you will share with us your perspective from the financial industry and being a data protection officer as well.
Thank you, Limor. By the way, it's lovely to see Maria. So that's great. I'll try to be not too long, actually, because I know we don't have a lot of time, but I wanted to say first a couple of words. So indeed, I'm the DPO for MasterCard, been very involved in our own sharing of data activities. So MasterCard has both open banking services, but we also have our Center for Inclusive Growth, which is doing a lot of data altruism. And as Thomas was saying, of course, it's about data, but it's very often rather about insights, about expertise, about technology and relationships that you need to actually do data altruism and enable the sharing of data. The other thing is that I was part of the expert group for business to government data sharing, which took place in 2019 and 2020. So that's really where I want to start. So what are the parties involved in data sharing and data use? So you always need to look at these 3 or 4 pieces. Individuals want privacy, businesses want to innovate, policymakers are regulating collection and use, but also the sharing of data and the transfer of data. And regulatory, well, their job is to enforce. And so if you look at it from the perspective of all these parties, we of course have the data streams between individuals and businesses, individuals and governments, etc. But what we are actually trying to regulate these days in Europe is both the B2B, so business to business data sharing, the business to government data sharing, and Maria was speaking about the Data Act to come, and the government to business data sharing. And so part of the Data Governance Act is sharing from governance to businesses. So it's very important for all of you to keep in mind business to business, business to government, and government to business. That will help you kind of look at it a little bit more clearly. Now then, we can go to the next slide if you want to. From a financial services perspective, we already have huge problems because we have overlapping regulations. So we have the e-privacy regulation, which is regulating metadata. And so for fraud prevention, for example, you use a lot of metadata. We have the GDPR, which is a great framework, and I personally was involved in the negotiation. I'm still very happy with it. And then we have the PSD2, the Payment Services Directive, which, for example, regulates open banking. So this is rather complex already. We've seen quite some opinions from the European Data Protection Board on how to marry PSD2, for example, and GDPR. And now on top of all of this, we're getting the Data Governance Act, the Data Act, and the AI regulation, and indeed even the Digital Services Act and Digital Markets Act. So this is a complex area where, big banks, MasterCard, etc., we can handle. We have privacy teams of 40 people. But one of the big concerns is how are SMEs going to do this, and how are individuals going to understand really what's happening. Now, if we then go to the next slide, that is where I really try to look at the different models that are being used in the financial sector and in the DGA. Now, for you to remember what Maria said, the DGA introduces data sharing from governments to businesses. It creates intermediaries. That's the second point. It creates a market for data altruism. it creates new regulators, the Data Innovation Board. And what I would add to that, it enhances individual control over data because of the data cooperatives. So we have really very different elements of a data sharing ecosystem in this DGA. Now, looking at it from the financial perspective, the first thing we see, open banking. Open banking is mandatory. So the bank gets a request from a fintech. The bank has to provide that data to the fintech if the individual has agreed to it. And it has to do it for free. If you look at the DGA and what public entities are supposed to do, it is voluntary. And the public entity may charge fees and verify. So here you see a different model. Then the open banking regulation actually regulates the providers of the data, the banks, and the receivers, the fintechs. The data governance, on the other hand, really regulates the data intermediaries. So it creates this whole new area where the pipes for the data are regulated and get supervision, which is really a very new concept. It's almost like the liberalization of the electricity sector in Europe, where suddenly the pipes had to be separate from the service, the entity that was providing the electricity. So it's a new concept that you see here in the DGA. Then in the PSD2, you see that there are license requirements. Here is registration. In PSD2, you have lots of technical service providers, but the oversight over them is by the banks. So they are not regulated, they are not licensed, no nothing. On the data uses, one of, I think, the big concerns under the DGA is that the data uses by the data intermediaries are very strict. So Thomas was asking, what's the business model? How are they going to earn money? And Maria is saying, well, they can ask for fees for providing the data. But I do think there are some questions around it, because what we typically see is that entities and individuals engage with companies because of a service, a benefit that they get. And because of that benefit, they want to share their data. So sharing your data with intermediaries, when you get really nothing back from it, there's a question about the business model there. Then I can say that DGA is very privacy-centric through those data cooperatives. And the PSD2 is really consumer-centric. It's all about contracting, engaging, T's and C's, etc. Perhaps some of the last points, and there are some concerns in the DGA about transfer restrictions that are different from the GDPR. Transfer under the PSD2 is approached very differently. It's approached from a risk-based approach, where the European Banking Authority says, as part of the outsourcing requirements, you have to be extra careful when you transfer data outside of Europe. And then the last thing, as a privacy person, is the whole question around consent. Consent is valuable in certain instances, but we also know that consent very often doesn't give the proper safeguards. And so the focus on consent in the DGA, is a little bit worrying from my perspective, because we know that it's very often, not the right tool. So let me stop there, Limor, and say, well, it's great to see the DGA. I think it's important. We support it. But, it's a different model, and the financial sector will need to start working with it and needing to get used to it.
Yes, thank you, Helena. Very excellent points. I'm especially thinking about your last comment about how will people be incentivized to cooperate with that. And I'm reminded of, I think it's behavioral economics and a few of the greats who have talked about the default, whether the default is opt-in or opt-out around consent, the big question that privacy professionals have been discussing for many years. It would be interesting to see to what extent people are willing to make the proactive effort in donating data, in showing data solidarity. And I think that one example that we have already in the past few weeks is the change in the recent change of Apple's iOS, where a positive active consent needs to be given for ad tracking. And I think that the last number I saw is that only 4% of users have consented to that data sharing, which doesn't, I'm not saying this from a judgmental perspective. Maybe this is the right thing that needs to happen in the ad tech business, and data for public interest reasons may be different, maybe not. Maybe there is a public interest there as well, but it's definitely, it would be interesting to see how this unfolds. So thank you again, Helena, and we will be back to all of our speakers soon. But last and definitely not least, Rachel Ran is our next speaker, and Rachel Rachel is the data policy manager at the ICT Authority in Israel, and she will share the government perspective, which Helena was kind enough to emphasize for us, and truly so, the access between government and businesses, and Rachel has been working on this for the past few years, and please share with us your perspective from within government, and as a person who is engaging other government ministries and bodies and trying to motivate them into data sharing.
Okay, thank you, Limor. So just before we start, a brief introduction into the ICT Authority. The Authority is the leading agency who's in charge of technology and government. And as part of our work, we also lead the government data policy along with many partners from within the government. This is just a little background about us and what we do. And I'll try to keep to the time frame and not repeat what was already said, but please excuse me if I do. So when it comes to data, governments obviously have different, sometimes contradicting roles. We are facilitators, regulators, or service providers, possibly more. So my focus in the next few minutes is on our role as the executive authority in the most literal sense of executing policy by defining and implementing actionable goals and effectively communicating those goals. So specifically is how we promote both data governance inward and what we do with data within the government, and how we wish to encourage data sharing. So one of the first steps in the process of data governance for us is creating a clear, relatable concept that centers efforts around key subjects. And in this context, in our effort to promote data governance, we adopted and often evangelized the concept of data as a product. And just to be clear, we refer to data as a product, not as a commodity, in the sense that data products, such as APIs, for example, should be based on user needs and focused on generating value. We do not refer to data as a product by commodifying or commercializing government data, though it can be applied to the suggested framework of the DGA in this context. And I'll elaborate on what we mean by data. Data is a product. So essentially, we have four basic principles that make up this concept. First is that data needs to be discoverable. It needs to be easily discoverable by using shared platforms and having very detailed and accessible metadata. Data needs to be interoperable. It needs to have common entities, technical standards, and business definitions. The data also needs to be self-describing, enabling self-service through clear and comprehensive documentation, and reducing the dependence of data users on the data holders or the origins of the data. And finally, and definitely not least, it needs to be trustworthy. There needs to be transparency of the sources, the manipulation, the lineage, and the general reliability of the data that users are accessing. So the concept of data as a product, and this is relevant to how we work with other agencies and ministries, the concept really resonates with people who work on digital services and data, because they recognize the processes and the stakeholders that are needed to carry out the change, and they understand their roles, and they can appreciate the benefits of providing good service to users. And in this regard, this was also mentioned, one of the main projects that we are currently working on is actually creating standard APIs, both for G2G, government to government, to improve our digital services, and both for G2B, how we make the APIs accessible to businesses. And obviously, this is not without its challenges, and I think those challenges are common to most countries from what we've seen and what we've heard. And the first one, which is very fundamental, is data standards, because we are in a system that is very distributed, and our structure is very distributed, and obviously the data is fragmented, and that results often in duplicate records or errors in data and inconsistent formats and definitions. And that means a lot of effort and resources are put into data cleansing and transformation. And this also results in suboptimal digital service design. And possibly also a suboptimal decision-making, because we don't always have all the data we need to make a decision. So to this end, the definition of domains or data spaces in the EU data strategy could be effective in defining the scope and focus of the work that needs to be done and the technical and business aspects of its standardization. Another key challenge that we face, and this, I've seen some questions and comments about de-identifying data. So when we set out to promote, this is coming from the Open Data Initiative. So we set out to promote the open by default principle for open data. And one of the main challenges was finding solutions for data that cannot be universally open. And we've come to find out that it takes a lot of skill and a lot of experience to identify the right balance between data utility and protecting personal data, because the more you protect the data, the more you aggregate it, obviously you have a less usable data set. So how do you balance that precisely by actually preserving the utility and protecting personal data? And we've also come to realize that probably you're not going to be able to maintain utility and make data completely unidentifiable. It is, if you maintain utility, it's probably reversible in some way. So that makes things a little bit more complex. And it is worth considering the level of involvement that we would expect from the government as a regulator when regarding intermediaries in determining how data intermediaries can strike that balance, and how deeply do we go into that policy and the regulation of that balance. And finally, organizational culture and data literacy. So in order to succeed, we need an organizational culture that supports this type of change, that understands and promotes data standards, quality, and openness as infrastructure for all government activities, or as an infrastructure of infrastructures, if you will. And it is worth mentioning that our current framework makes it extremely difficult to share data even within the government. So sharing it with external stakeholders requires a really fundamental change of perception, at least for us. And just to sum up, presenting the concept of data as a product is a tool for adoption. It creates a common language that is focused on shared and actionable goals. And in the most pragmatic sense, that is the role that we have taken on. But this brings to question a deeper look into our roles as a government and which ones we outsource. Do we do so because this is the best way to solve a market failure, if there is a market failure? Or do we lack a competency and believe that other bodies can do it better? And however you answer these questions, in order for governance initiatives of this kind to succeed, trust is essential, which is trusting the government's ability to truly govern and regulate, as well as trust in the data and what is being done with it by the government. Thank you.
Okay, thank you, Rachel, for providing the government's perspective. I have plenty of questions. Now we're time for the discussion. I have plenty of questions to all the panelists, so I'll just make two brief comments and maybe start with Maria, because so many people have made different comments on the DGA. So one comment, kind of more of an observation as a law professor, right? Everyone has their own flaws. So usually when we think about markets and regulation, we get it the other way around, right? We start with a market, there are activities taking place, and then the government comes and says, okay, I need to put restrictions on these markets. And here, to some extent, we have some, regulations or regulators or the government that has a vision for the market, and it tries to create it. And then you get all these questions about why did you set these standards, and are you sure that this is going to work? And maybe you need to wait, maybe the right way to do it is to wait a bit and kind of see how the market develops. This is just an observation. I mean, if it works, it would be excellent, but there is some risk here that it wouldn't work eventually, because you'll build it, you know, and nobody will come, you know, as the famous movie from the US talk says. And another observation is, you know, can we really, you know, going back to some of the questions that were mentioned in the chat, can we really set the rules here with taking no position on ownership and who owns data and other issues like that? This is, again, another observation, but maybe it's time for me to let you see if you have any response to things that were mentioned by the speakers.
Thank you very much. I don't know where to start. Let's maybe start again from the ownership. It's not that we are avoiding it, the concept. Maybe it was Thomas that was talking also about that. And while Thomas was talking, it was funny for me because he mentioned several issues that we are currently discussing in my unit for the preparation of the Data Act. So, for example, if I have a smart fridge, and you know, it breaks, I mean, who has the right to the data to repair the fridge, and etc. I mean, if who is the owner of the data produced by my car, and all these kind of issues. The discussions are very complex, also because we are going towards more and more data produced by sensors, by objects connected to the Internet of Things, and we are moving from the cloud computing to the edge computing. And I cannot just say that, you know, everything is easy, and we are really encountering also difficulties because the discussions around those topics and the balancing act, as I don't remember who was mentioning the balancing act between, maybe Rachel, between the utility of data and, for example, the anonymization, because more you anonymize data, maybe the less they are useful. But we are reflecting on that. And I think I cannot spoiler too much, sorry for that, on the Data Act. But maybe the public online consultation that we are going to launch maybe can also start to clarify some ideas of the direction where we are going. Also because when you talked about usage rights, Internet of Objects, data from Internet of Objects, there are issues related to intellectual properties. There is the database directive that is going to be reviewed. The discussions are complex, and we try to give at least a first starting point to going forward. And then we see how things will move. On the DGA, I mean, the DGA has been really quite an important piece of legislation, we think. Also to maybe open the floor to other discussions and ideas. And thank you, Elena, for highlighting how the DGA also complement our policies on the open data, because the open data policies of the Commission is well established. Did not started with the DGA. The DGA complement the open data directive because looks at those data held by the public sector, but that are sensitive. So these data are not in the scope of the Open Data Directive. So with the DGA let's say open up those data, so provide more data to be used by companies, by individuals. On the issue of consent, indeed is another complex one. There are some provision in the DGA, in the chapter on the data altruism, that says that the data altruism should be further supported by providing legal certainty on the use of broad consent. For example, consent given to areas of scientific research, lowering the standard for specific consent under Article 7, in accordance with the consideration of recital 33 of the GDPR. And for this reason, the Commission will establish a specific consent form by way of an implementing act. So we keep reflecting on all these issues. Then what else? On the use of the data, on the business to government data sharing, this will be again part of the Data Act, but it's important to clarify from the beginning that we will not do business to government data sharing to help government getting access to citizen data. The business to government data sharing is all about benefit the society. And we benefit society also if we give the public sector better tool to implement more efficient and evidence-based policies and services. I think this is going to be quite interesting under the Data Act, because we also receive lots of call for action, like what is, especially for example, after COVID, in this pandemic, we have really realized how important it is in an emergency situation for the public authorities to have the tools, the data to spread to monitoring the spread of the virus, for example, to monitoring how the confinement measure are effective or not, to build epidemiological models. So, and we have experienced it ourselves, how difficult it is to establish business to government partnership, because, for example, the Commission has a project ongoing with some mobile network operators to collaborate on sharing the data, to understand all the issues that I just mentioned, like the spread of the viruses and etc. And it was pretty difficult. Also for the private sector that wanted to help us, they didn't even know who they should have contacted.
Hey, Maria,
there are again lots of issues involved.
Definitely, there are a lot of issues involved, and we have only so many few minutes or so left, and I do want to get the perspectives of other members of the panel.
Yes, sure.
And I'll try to do it like in reverse order. So Henriette, you mentioned in the chat the difficulty, going back to Helena's presentation, about reconciling sector legislation with broader legislation. So maybe you can comment on that a bit for us.
Yeah, I am increasingly concerned, and I was before this presentation, and I'm now even more concerned that the EU, but it's not an EU issue, it's an issue for every country, I think, is thinking too much in silos, in the sense that you have the sector legislation for the banks, PSD2, then you have the privacy legislation, now you have data legislation. There is simply too many definitions floating around, and in the sense that we need to realize if this thing is going to work, whether it's now DGA or any other piece of legislation, at the end of the day, there are actors in the field, whether they're called banks, whether they're called governments, whether they're called other commercial entities, that are wearing, per definition, different hats under all of these instruments, but at the same time, they need to comply with all of these requirements. And if these requirements contradict one another internally, this is never going to work. And I don't know what the solution is. I am afraid I'm just raising the issue. I've seen it before with PSD2 and the GDPR, which I think is not solved yet. Now the DGA seems to be sort of a repetition of the same team. And I would think that there must be some sort of superpower out there that before all this legislation comes out, it would be good to sort of see, well, this contradicts actually X, Y, Z in another area. I don't know who this superpower would be. The legal department of the Commission would, I'm sure, play a role in this. But I see this as an increasing concern and as a serious impediment for the success of all of these legislations, which in and of themselves are good. but when you combine them, they present some challenges.
Hey, thank you. I must admit that as a law professor, I always have mixed feelings when people make these comments, because on the one hand, they're necessarily correct. On the other hand, if things were not so complicated, you know, what would lawyers and what would our students do, and how do we get
Absolutely
their living? But
you don't hear me complain. So.
Okay, it's altruistic on your part to make this comment. That's what you mentioned. Yeah. So a quick question for Thomas. You know, I've read somewhere that some cities, you know, now don't wait for government regulation to just ask as a condition, for example, for having a mobility autonomous vehicle. They say you can get a license if you make the data public, right? So maybe instead of, like, you know, especially if we have new industries that require new licenses, maybe this is something that we need to be thinking about, right? Mm-hmm. Pre-requiring certain industries to share data before they start operating. Yeah.
So you know, and this is not a comment specifically for Maria, but I reading, you know, again, you know, maybe it's an early draft of the DGA. I wish there was more mention of the data cooperative, because we're very interested in our group and also in the United States in you know, trying to solve some of these particularly community-oriented problems with this construct called the data cooperative. And so the idea is pretty simple here, that instead of talking about data ownership, it's to give individuals copies of their data and therefore empower them to use it for whatever purpose. So, for example, you know, so today, you know, and you know, I can log on to my bank. You know, I've got a MasterCard, Helena, so I can download all my transactions fairly easily. .csv file, terrific. But I can't do that for my AT&T mobility data. I'm an AT&T account. No, I'm not hitting on AT&T specifically, but in the United States. But first step is enabling individuals in a community to gain access to just copies of data that mentions them, data about them, regardless of who made the data, whether it's a phone carrier, whether it's Apple, you know, electronic, whether as you know, the example of the car generating data. So that's the first step. The second step is using the model. What we have here is, you know, so we have two sort of types of financial institutions, consumer-facing institutions, is the banks, and then you have credit unions. So when you walk into a credit union, the atmosphere is different because they call you a member and not a customer, right? So you are a member of a credit union. So to give an example, we interviewed, we visited and discussed, you know, this problem with several credit unions. There's one in the next state over that has 60,000 members. And so we were trying to explain to them that the same model could be used for personal data. So if your members, your 60,000 members, could have access to copies of their personal data, they could provide that copy to the credit union, and the credit union can do interesting analytics about the membership. Things like, is there a change in the age group of my membership? How many families are young families, right? So you say, well, that's, you know, for a community to understand their own situation and changes is very powerful. It's very empowering for the community, and it allows them to plan for the future. So the credit union, literally, I sort of use this example. The credit union could say to the credit union that has your personal data, could say, oh, well, you know, 30% of my membership have babies. Well, great, I can go to Amazon and negotiate a discount on diapers, right? And you think, well, that's fantastic. That's additional sort of, you know, benefits that are not necessarily measured in dollars, you know, and healthcare, you know, discount on health insurance, because, you know, for many communities in the United States, it is a big challenge to get, you know, affordable health insurance. So that model, you know, allows, it cuts sort of both ways. It allows businesses to come in and help these data cooperatives. So to give you another example, this credit union with 60,000 members, they actually don't own any computing infrastructure. They actually outsource the running of all the computers, networks, data storage, account management, banking, you know, all this stuff to a IT services company. And more interestingly, the same platform that was being operated by the IT services company was actually shared by 2 other credit unions, one in Texas, one somewhere else, right? And so the point is that, I'm bringing this up, is that this data sharing provider, entity that's identified in the DGA, it sounds to me like this IT services company that could help a data cooperative, right? And so in times of emergencies such as COVID, pandemic, we're going to have some more pandemic, folks. I guarantee you, but in anticipation of future emergencies, the data co-op members could vote, literally say, yes, I want to make my location data available to my town manager or to my state government, because I know it's very important for the community to stay healthy, right? And you can turn it on and off. And after, anyway, I didn't want to sort of drag on, but
Thomas, thank you. I'm sorry for cutting you off, but we have just 1 minute left, and I want to give both Rachel and Helena the chance for one concluding sentence. So Rachel.
I just want to draw on the conversation about data cooperatives, and I want to mention, go back to user needs and mention that those kind of initiatives define the best business questions. And we need to remember, when we're dealing with data, we always need to be led by the business question. We don't share data just for the purpose of sharing. We want to solve some kind of problem. We want to improve something. And those kind of initiatives, they're kind of better aligned with the interests of who holds the data and the not owners, but who are the subjects of the data, and whether they can preserve the flexibility of who they want their data to be exposed to and what they want it to be used for. So I think that's a very innovative and interesting approach and direction to go in.
Very, very true. Thank you, Rachel and Helena.
So last words from me, 2 things I would say. So there are lots of data collaborations already happening, and we'll need to make sure that regulation doesn't cut it out, because as Rachel was saying, it's through certain use cases that collaborations start to exist, and then they work. It's just the transaction cost and the time to build, that's the problem. Mm-hmm. So we need to facilitate it rather than make it more heavy. The other thing I would want to say is that the question around data portability, if we could just increase data portability rights like they're doing in Singapore and in Australia, that could also be an avenue for creating much more flexibility in the data market. So those are my 2 final remarks.
Thank you so much to everyone. Asaf, last chance.
I thank all the speakers. It was fascinating, and look forward to read the next draft of the DGA.
It was a great pleasure. Thank you everyone for joining us. Thank you to all of the attendees. We will make this recording public, and thank you for joining us live today, and have a great evening. Bye-bye.
Thank you, folks.
Thank you. Bye.